This is a current trend case brief of the Court of Queen's Bench of Alberta ISW v DK dealing with the child custody. The citation is ISW v DK 2020 ABQB 151. Facts. The father ISW has appealed to the court requesting a primary care parenting of his 4-year-old son FS, while child's mother DK has cross-appealed for mobility. Both parents currently live in Edmonton, Alberta, but they reside separately due to their complicated relationship. The current order by the Manswick J on March 15, 2018 grants the father ISW assigned parenting time every Saturday from 11 a.m. until 5 p.m. The parties lived together for roughly 2 years from June 2014 until April 2016, while their child FS was born on December 2015. The parents were never officially married according to Canadian legislation. However, DK claims that the traditional Muslim marriage between them happened in October 2014. The main reason for DK leaving ISW's house on April 2016 was an emotional and physical abusive nature of ISW. The mother, DK, is willing to move to Brooks, Alberta since she got married to a man named Adam who has a job there. Both ISW and DK are now married again to different people and each have a child younger than FS. ISW acknowledges the fact of him having a wife and 2 children in Ethiopia. ISW currently manages an auto dealing company named B Cleaning. As it was defined by the courts, the parties have high conflict relationship. Adam, the DK's new husband, has agreed to live together with DK and FS and support them financially in Brooks, Alberta. Since the separation of the parties, DK, the mother, had the primary care of the child. Issues. Number 1. Since there are an application and cross-application received from the parents, which parents should be granted a primary care over FS? Number 2. Should DK, the mother, be granted with mobility for FS, the child? If so, on what terms would the father be visiting his child? Decision. The mother's motion for the child's mobility was met and ensured. The father's motion for primary care was dismissed, but he was given a right to pay a sum of $0 in child support from March till June of 2020 due to the transportation costs implied to get to the child's new home in Brooks. Rationale. Issue number 1. According to the Section 18, subsection 2 of the Family Law Act, the decision on primary care should be made based on the factors regarding the child's best interests. Therefore, the mother, as a parent a child is most accustomed to, being changed from a primary care parent to an access parent would have a greater negative impact on the child, especially with mother's relocation. A father remaining to be his access parent would have a less psychological impact on FS, since FS was living with his mother after separation. Issue number 2. According to the Supreme Court of Canada legal framework in Gordon v. Kurtz, 1996, a parent seeking for a shift in guardianship must show a substantial change in the circumstances impacting the child. This condition was satisfied since Adam, the mother's new husband, has got a job in Brooks and agreed to financially support her and the child. Moreover, a local Ethiopian community is providing the mother with a job there. However, based on this issue of fairness, the traveling expenses ISW would pay traveling to Brooks to access his son are going to be subtracted from the child support payment resulting in no payment from him during the period of DK's pregnancy. She is currently not able to drive FS long distances to see his father because of her condition. Analysis. Since the mother, DK, was a primary caregiver for FS after her separation with ISW in April 2016, the child is certainly more used living with his mother and is more probably attached to her. since he was seeing his father only once a week. Moreover, since ISW manages an auto detailing business, he is more likely to have little time looking after his son, unlike FS' mother, who is currently on the maternity leave and doesn't work. Moreover, there is a big Ethiopian community in Brooks, so the child will be raised in a sense of belonging to his culture. Therefore, I believe that ISW's appeal was fairly dismissed according to the child's interests and what is psychologically best for him. Survey question: should the preference be given to mothers in the court processes determining a parent of primary care?